Good evening, everyone. Welcome to the episode of Business Report. This is a case of the ATO in respect to the Commissioner of the Taxation was paying 2001. The case is narrates the perception of the ATO in regard to the ruling that the judges made in the case and why it is necessary to effect some changes to the Income Tax Assessment Act 1997. The stories in a form of question-answer and time narration constitute a story as told by the ATO after the judge's decision in the case. Payne is a taxpayer who carried out to the dairy farming business and employed by Qantas as a polite at the
As the Commissioner of ATO, we were awarded that AAT had legal powers to mediate effectively in matters related to taxation involving the taxpayer and the Commissioner. This was the expectation of ours towards the AAT in handling Payne's objections. However, when the AAT made the decision and the taxpayer filed shortchanged, he appealed in the federal court. The court allowed he appeal where the taxpayer's prior for the Commissioner's objection to the review afresh by the AAT was granted. The taxpayer's position and the submission to the federal court was that the AAT had in the first place of handling in the case error in law by denying the deduction. In addition, the taxpayer aim was to leave in order to file a notice of contention with the High Court that his decision had made premised on the past public ruling, which is perspective was opposed to the binding on the Commissioner in claiming the deductions. Therefore, the concern of the ATO was that if the taxpayer appeal could be allowed, all matters related to whether or not the taxpayer could relate on public rulings in the past should be remitted to the AAT. The idea of the ATO was that the AAT and the not be court was better placed to be deliberate on the issues effectively.
Consequently, by applying to the full court of the High Court, ATO was concerned with the federal court attempt to dismiss or use up constitutional powers for the AAT, especially in making critical decisions of the taxation. Therefore, it is possible that ATO was keen to ensure rights of the AAT are not infringed by the federal court.
Sir.
Hi Payne, what do you think of the decision that made by the court?
Well, I have found a notice of contention with the High Court to the effect that I had relied on the public rulings which were binding on the Commissioner, in particular 95.19, which dealt with the airline industry employees, and I think the traveling expense between the airport to the dairy farm is a work-to-work expense, so I need to claim that the cost is the deduction.
Thank you.
The Federal Court and the full court of High Court made independent different decisions to the same case. The Federal Court allowed the taxpayer's appeal while at the same time dismissing appeal by the Commissioner. The decision by the ATO to appeal was largely motivated by the concerns about the impact of ruling to future claims. The majority of judges in the Federal Court ruled that expenses incurred by a taxpayer while traveling between a place of business and a place of employment qualified a lawful deduction result, putting into consideration the aspect of two places being unrelated in terms of income derivation. However, majority of judges in the full court of the High Court ruled that travel expenses incurred between two unrelated income-producing activities did not meet. Therefore, if the decision of the judges in the Federal Court could have been upheld, then it would have been possible for more future claims to occur where taxpayer apply for a lawful deduction without having to worry whether or not two income derivation locations were related or unrelated. This could have been an expensive affair for the Commissioner, since it would mean that many people involved in different unrelated economic activities in different locations could pay less in terms of taxes as a result of deduction. Thank you.
The way of the ATO in developing the new Section 25-100 to the Income Assessment Act 1997 is to have a clarity on the deduction of expense incurred on traveling between unrelated producing activities. Besides, the law aims to clarify whether or not allowable deductions should be extended in the case where the travel is to or from the residence of the taxpayer. Therefore, creation of some features in the new Section 25-100 constitutes a necessary move to eradicate confusion and uncertainty as expressed in the ruling of the two courts. The primary idea in the new law is to permit allowable deduction of transport expense on only to have an extent where such expenses are incurred by the taxpayer when traveling between workplaces. In this way, traveling between workplaces should be considered to take place only when a taxpayer is traveling between two places, and the travel is such a way that while at the first place, the taxpayer engages in activities meant to gain or produce a sizable income. In addition, the travel between the two places, while the taxpayer is at the first place, he engages in activities in the course of performing a business activity, which has capacity to enable the taxpayer to gain produce a sizable income. Apart from this, a clear link has to be established between the first and the second place of travel. This is whereby, for allowable deductions to occur, the taxpayer should be in a position to show that the purpose of the travel to the second place is purely to engage in activities aimed at gaining a sizable income. Also, the travel should be based primarily on the purpose of engaging in activities that in the course of carrying on a business with the aim of gaining a sizable income. This is our presentation, and I hope you will enjoy this. Thank you for your listening.